Yellow Cab is in the court, where we slice the real-life courtroom action apart to reveal the strategy and psychology and law behind every word uttered in the courtroom. In today's case, People v. Daniel McGuff is an ordinary DUI trial that turns out to be a tense show of legal uncomprehension, confusion, and judicial tolerance. Wait about it, because that which comes next is a lesson to every defendant in one important thing about defending oneself in court. Get more real courtroom analyses like this one. The calm before the storm. The hearing is started in silence, in order, in almost mundane, as hundreds of other hearings have been started. The case of People v. McGuff is called by Judge Cedric Simpson, who was famous for his calm authority. Daniel McGuff. On the one hand, McGuff does not seem to be a stubborn person. He is polite, answers when he is spoken to, and even seems to be a follower of what the judge is asking. However, there is something fomenting behind this surface, and that is confusion and mistrust. When the judge starts explaining the specifics of the procedure, the discomfort of McGuff can be observed. His tone shifts. His replies begin to play about themselves. The courtroom setting becomes stricter. The court of Judge Simpson operates in transparency. All instructions are supposed to be fair. Yet the nature of the responses that are given by McGuff indicates a misconception of the whole process. He not only starts to doubt the facts, but even the validity of the procedure itself. Such happens to be a widespread thing with self-represented defendants who consider their understanding of the law to be more important than the courtroom order. When McGuff starts answering easy questions with such phrases as, "I do not know what jurisdiction you have," the initial indication of confrontation is created. This is not going to be just a hearing. The audience knows, and even the prosecution knows. The most interesting aspect of this opening is the quiet manner in which it builds up. There is no dramatic moment there, no screaming, no banging gavel, but the tension is increasing with every word. Judge Simpson remains level, but his voice is starting to give a tiny hint of caution. It is not a matter of choice whether to cooperate or not. What McGuff does not understand is that the harder he attempts to charge, the less charge he is having. When this initial dialogue is over, the room has gained some weight. What began as a peaceful process is now a trial of patience and integrity. However, it is just the start, as the second stage introduces the issues of legal identity, due process, and rule of law defiance.
You know something, sir? Just because you use what seem to be legal words and try to place them into a sentence doesn't mean that it makes sense. Court does call the case of the People versus Daniel McGuff. You're going to represent yourself?
Yes, Your Honor.
Okay, what are we doing?
To begin, I'd like to just announce a brief summary of the incident that happened.
Pardon?
The incident on October 11th, the reason why I'm here. I would just like to announce a brief summary of what happened.
And that's going to get us where?
Well, I did file a motion a couple weeks ago for discovery. I do have a copy of each.
Yeah, no, I saw it. Did you get the discovery?
I did not. But I don't think I properly served it on the prosecutor, so I'm here to do that today. I did serve it with the courts. I did file with the courts.
Oh, no, I saw it. So what do you want me to do with your case today?
Well, I a few things. I want my bond conditions lifted. I want a discovery. I don't know exactly what the procedures here, as you know, that wrongfully.
Yeah, I know, because as you're talking and as everything went through, I could tell you didn't know.
Yeah, sorry. But I'm trying my best to do things right. But I just
Okay, you haven't started out well.
The legal identity crisis. As soon as McGuff speaks the words, "I do not consent to these proceedings," the energy of the courtroom is changed completely. It is not just defiance, but it is a declaration made out of a serious misconception of sovereign citizen ideology. McGuff starts to separate himself with the corporate fiction of his name, the way it is presented in the charging papers. This is not the first time that Judge Simpson has encountered this, and his face is unshaken. His eyes, however, so keen and alert, tell him that he knows where this leads. It is no longer about guilt or innocence, but about understanding and power. Be it his misinformed faith in the online information or his own belief, McGuff refuses to acknowledge the jurisdiction of the court whatsoever. The irony? His dismissal itself is a testament to the authority upon which he is attempting to break free, in that he is standing in that courtroom and is responding to charges pursuant to state law. Judge Simpson tries to bring him back to reality by telling him that the name of the complaint, Daniel McGuff, is his name, the one before the court. But McGuff demands legal separation, playing at semantics with such phrases as the entity known as or the man standing before you. They are red flags to an experienced lawyer. They are a belligerent warning of possible contempt to a judge. Still, Simpson doesn't erupt. He's measured, professional. He understands that anger is a source of rebellion. He instead cuts through the fog with precision, a cool legal reasoning. But McGuff does not believe it to be the clarity. His vision is controlled. This identity crisis is the prelude to all that comes after. It is not only a misconception of law, but a psychological fight between faith and fact. The following scenes show whether McGuff will be able to come back to his senses or not. There are his beliefs that will put him into another procedural trap of which not many self-representing defendants can get out.
The first motion was to compel the testimony of officers at a deposition. I'm asking the court to deny that. As the court is well aware, depositions are not appropriate in criminal court. Request for discovery, where the defendant appears to be requesting that we produce different discovery items, as well as there's a sentence that says the defendant possesses exculpatory video footage. Request an opportunity to submit it for review. If he wants to give us something, that's fine, but I just think he should go through the normal discovery process, and I'm not saying the court not order what he's requesting in number 2, because it doesn't appear that there's been any request filed for discovery that hasn't been fulfilled or completed at all.
When he submits his request for discovery, then I'm going to deny that one specifically without prejudice.
Request for the people to get medical records for some person and give those to defendant. I responded that request was unclear, but it appears to be that the people execute a search warrant to obtain medical information for an alleged witness who does not appear to be mentioned in the police report currently in possession of the people. Unless otherwise directed by the court, the people would think that the people do not intend to execute a search warrant to seek out private and potentially privileged medical information for this person.
I'm trying to follow the rules of federal civil procedures, and this is my first.
Federal?
Federal, yeah, this is.
Yeah.
I think so.
Okay, so we're a state court.
Okay.
And this is criminal proceedings.
The illusion of control. It may look like a strong idea to represent yourself in court, yet it is a choice that can lead to a disaster most of the time. A case in point is that of Daniel McGuff. McGuff interrupts the judge on several occasions as the judge elucidates his rights with so much patience, and he believes that he is being duped into a confession of guilt. He does not know that any delay, any attempt to deny the authority of the judge is a cut to his credibility. Self-representation provides a defendant a voice, but it is a two-sided sword unless the defendant is legally literate. The pseudo-legal dogmas adopted by McGuff may seem to him very strong, but do not have any legal force. This is because he tries to dictate the story, thus being the harder task to assist him. It hurts the irony. He is fighting with the same system that would have defended him had he only known it. The voice of Judge Simpson narrows a bit. He is still patient, only taller, more to the point. He once again explains that the court is in a position to do so, and the hearing is not a debate, but a process. But McGuff isn't listening. He is acting. He is either saying it to himself, or he is saying it to some kind of belief that the law is not going to believe you unless you merely say the right words. At this stage, the viewer feels the inevitability. McGuff thinks he is making his independent statement. In reality, he is self-isolating, without counsel, without strategy, without understanding. This is noticed by the judge, and he is in a tough decision to keep on learning or to start enforcement. And here, where patience and punishment have to walk the fine line, this is where courtroom authority really comes out. Since the following exchange indicates the extent to which a judge can go in order to defend justice as well as dignity, once the boundary of respect comes into focus.
To represent yourself, you're constitutionally entitled to do that. I will apprise you that you are before the court on the charge of resisting and obstructing a police officer. You understand that charge?
I do.
All right. That is a felony or a high court misdemeanor. It is punishable by up to 2 years incarceration and $2,000 fine plus court costs. You understand that?
I do.
All right. You also understand, sir, that there can be great peril in representing yourself.
I understand.
You understand also that at this proceeding and any other further proceeding, that the court is going to hold you to the same standard the court would hold anybody else to. And the court will not play favorites. The court will not help you out. The court will not be assisting you. You understand that, sir?
I do.
All right. If at any time you wish to be represented by an attorney, and if you cannot afford to hire an attorney, but if you wish to be represented by an attorney, the court will afford you that opportunity to be represented. You understand that?
The breaking place. In any court of law, there is an invisible boundary, and that is where the patience of the judge stops and the power of the judiciary starts to manifest itself. In People v. McGuff, it is not crossed with shrieking, but with repetition. McGuff continues to demand, "I do not comprehend your jurisdiction. I refuse to give a plea or even accept the charges." Composed and deliberate, Judge Cedric Simpson provides numerous possibilities to allow McGuff to comply. He rephrases, clarifies, and even pauses, giving the defendant room to change his mind. But in the circular defiance, in the circumvention of explanations into refusals, the law must proceed without permission. It is then that the courtroom is transformed into command and not conversation. The tone of the judge is lowered. His sentences become firmer. He reminds McGuff of the fact that he will not participate, but the legal process will continue. At that point, you get a feeling of the change. It is no longer a conversation, it is a judgment. And here the mastery of Judge Simpson is. He doesn't lash out, he doesn't ridicule. The structure of justice is merely enforced by him. The tone, posture, and timing he takes control of prevents the courtroom from being plunged into total disorder. Even McGuff, temporarily thrown silent, appears to know that this is not a game of words, but a system of consequences. To the audience, it is a lesson on judicial restraint. Authority is not in the screaming, it is in the presence. The silence of what follows what the judge is saying is equivalent of a gavel. At that, McGuff has not abandoned his challenge. He goes on to counter his claims by asserting that he has not been read his rights accordingly. It preconditions the following twist. He does not know that the Miranda rights he is claiming are not relevant in the way as he thinks they are.
I'm going to take a break because I have to have something happen before noon. I will call the Spanish case up afterwards. I will also then call the one plea, maybe, that we have, and then I'll recall your case in the next block.
Okay.
And then maybe between the time I leave this bench and come back, you'll figure out exactly what you want to do.
Yeah,
and maybe how to do it.
I'll do that.
Or maybe if you want an attorney to represent you to help you through this process. Because
Appreciate
otherwise, this thing could much go south for you.
Yeah, I understand.
Not be good. But I'll let you think about that. That's your call.
All right.
Court's in recess. Court recalls case People versus Daniel McGuff.
That's the line of the people.
In your honor.
State your name.
Daniel McGuff.
All right.
Your Honor, when the court passed this case and left the bench, the defendant did hand me a copy of his motion. I took the recess of the court to file a response. I hand-delivered it to the defendant.
The Miranda misconception: rights, reality, and rebellion. When McGuff mentions his rights to Miranda, it appears to be a valid argument, but an ill-informed one that many defendants share. Miranda warnings are used when a suspect is detained and is under interrogation, and not when he is in a court of procedural hearings. Their mention by McGuff in open court confirms that he is perplexed by the distinctions between the courtroom process and police procedure. Judge Simpson, who was aware of this difference, is confident enough to state that the hearing is not about interrogation, it is about arraignment. However, to McGuff, the explanation given by the judge is an evasion rather than education. He has been ensnared in a system of beliefs in which words in a legal system are magic words. Utter them correctly, and the system will cease. The tragedy is that there is no such magic. In practice, in the actual courtroom, law is relative, not absolute. All rights are conditional and time-based. Miranda secures you when you are being interrogated. The due process secures you in court. The fact that McGuff fails to isolate the two triggers a series of opposition. Judge Simpson understands that he is confused, and he does something that is not obvious yet strong. He stops. Silence. He allows the words of McGuff to be suspended in the air, thus revealing their own non-existence. The courtroom does not have any sound besides the soft rustling of paper, neither humiliation nor a mirror. In his completion of McGuff, the judge is methodical and unshaken. He gives the plan of what to do next, scheduling, next hearing, and possible counsel options. It is obvious to the viewer, Simpson is not merely running a courtroom, he is instructing one. But McGuff does not take the lesson. To him, every explanation represents a trap. And this confusion of faith with law brings the hearings to the next, the most instructive stage, that of the illusion of sovereignty striking against the fact of consequence.
A request for suppression of this evidence until full
Suppression of what evidence?
of body cams, squad footage.
On what basis would you be doing that?
Miranda versus Arizona.
Which says what?
That I was not read my rights prior to being detained.
You're going to have to put more in writing for me to even understand that, because as it stands here right now, based upon what you told me, I'm going to deny your motion.
Deny my motion to suppress under Miranda.
As you're calling it, your motion's denied.
The sovereign fallacy, when internet law meets real courtrooms. At this point, it is evident Daniel McGuff is not just lost, he is acting. His words reflect the rhetoric of sovereign citizens, full of assertions of a natural person, contractual consent, and strawman identity. Such words spread in cybernetic circles, where fake rules take the place of the real rules. What is sad is that McGuff appears innocent. In earnest, he thinks he has discovered some legal loophole. It is not the first time Judge Simpson hears it. Many judges have. They are aware that these arguments are not resistance, they are fake empowerment masquerading as such. Simpson listens without interrupting, after which he breaks down the logic step by step. He is explicit. This is a courtroom that is regulated by the Michigan law and not internet mythology. But McGuff can't accept that. The sovereign story offers liberation with the government power, an illusion of control which is thrilling to the power-averse ones. But the courtroom is the accuser of all. Words not backed by law are meaningless. The judge provides McGuff with all opportunities to turn around. He offers counsel appointments, repeats procedures, and goes to the extent of allowing time to clarify. But McGuff refuses and doubles down on his fake story. What he is unaware of is that the more he is talking, the bigger his procedural hole becomes. The viewer feels it. The fallacy is disintegrating. The undiscovered knowledge that McGuff uses is lost in actual examination. And still, rather than enlightenment, there is frustration in its place. Order in the court. Once a courtroom starts to get out of control, there is no more effective tool than procedure, which the judges apply. Procedure is not merely paperwork, but the legal structure which prevents the destruction of justice into argument. And when McGuff declines to join in, Judge Simpson resorts to that building. He coolly says that despite the consent of McGuff, the hearing will go on. It's a critical moment. By doing so, the judge reaffirms the court does not have its authority through personal authority, but rather through the set law. The gears of justice do not stop turning, however much McGuff may resist. McGuff makes another attempt to abort the procedure, posing that he is not consenting to jurisdiction. The judge reacts by reading the record line by line, which makes all the activities transparent. It is a brilliant courtroom maneuver. Cleaning up the record gives him the freedom to safeguard the court and the rights of McGuff. The courtroom environment changes once again to a scenario of inevitability. Even McGuff appears to feel that his fight is no longer in charge. Still, he doesn't relent. The most interesting aspect in this case is that Simpson does not lose his temper. He does not raise his voice, never offends, never scorns. He is endowed with the rigor of courtly temper, because in a court, no one takes authority, he shows it. At the termination of this stage, it is recorded that McGuff has been provided with all the opportunities to know and obey. The judge proceeds with the hearing by procedural laws, thus nothing remains ambiguous. And though the issue appears to be closed, the true emotional climax is yet to come, as McGuff still has not forgotten his feeling of injustice. It is just ready to explode in a last desperate effort to regain the control that is already stolen.
I also am requesting that there is full discovery in this process.
Okay, have you sent a request to the prosecutor's office for discovery?
I have not. No,
Have you asked them, how do I get discovery?
no, I will be doing
Did
that.
you ask anybody how to get discovery?
I asked a couple of the clerks, but they can't, give too much legal advice. So I'm trying to take as much responsibility for this as I can.
Okay, well, I'm gonna, at this point, deny that motion because there hasn't even been a request for discovery. If you don't get something, then you bring a motion for discovery.
Request for discovery, where the defendant appears to be requesting that we produce different discovery items, as well as there's a sentence here that says the defendant possesses exculpatory video footage. Request an opportunity to submit it for review. If he wants to give us something, that's fine, but I just think he should go through the normal discovery process, and I'm not saying the court not order what he's requesting in number 2, because it doesn't appear that there's been any request filed for discovery that hasn't been fulfilled or completed at all.
Well, here's what I'm going to do, at least at this point, is I'm going to deny the motion, that portion of the motion also. When he submits his request for discovery, then I'm going to deny that one specifically without prejudice. That way he can raise whatever issue he may have.
The final stand. When rebellion strikes reality. The tension is broken to the end. McGuff, reduced to his reasoning, redoubts. He denies making a plea, denies recognition, and requires the court to prove that it has jurisdiction. His voice is up, but not with anger, with desperation. This is not rebellion anymore, but disbelief taking its toll. Judge Simpson doesn't flinch. Here he is not new. He knows the style. Such defendants holding to pseudo-legal concepts soon exhaust themselves. In the place of argument, there is silence where words do not provide much. And there in that silence comes reality. Simpson procedurally records on the record that the refusals of McGuff will be relied on as a not guilty plea under Michigan. The case will continue. Jurisdiction is brought into existence. The process moves forward. That's when it hits McGuff. His declination did not prevent anything. The court didn't vanish. The paperwork did not vanish. Law didn't bend to belief. Rather, it took in his resistance and continued on. It is the time of truth to the viewers. The legal system, already accused of its inflexibility, demonstrates its strength. It does not counteract, it merely continues.
I'm not going to sit here listening to frivolous motions.
Okay.
I'm just not going to do it.
That's not my intent, Your Honor.
No, I don't care whether it's your intent or not. 3/4, if not 7/8 of that motion that we just dealt with was frivolous. It has no basis in law at all. You're just filing stuff. I'm going to tell you, I'm not putting up with that. Are we clear on that?
We are clear.
The case decision. After an hour of legal squibbles, confusions, and persuading the patient, it is time to pass a sentence according to Judge Simpson. The courtroom goes dead. The tension is dissolved in expectation. And what shall the judge do with a defendant who declines to submit himself to his jurisdiction but has done nothing to contempt? Simpson does something very extraordinary. He dissociates behavior and faith. Instead of chastising McGuff on his misunderstanding, he makes it a law and not an ego issue. He continues with the normal court procedure of issuing scheduling orders, setting the next appearances, and recording and preserving the rights of McGuff. He is a master of judicial ethics. When judges are confronted, it is easy to want to assert dominance, but Simpson curbs the urge, thereby turning confrontation into an educational experience. His voice remains strict and yet humble, and the point is clear. You can be disrespectful to the law, however, the law will defend you. McGuff starts to calm down, but visibly annoyed. His rhetoric is cold with fire. Or perhaps he feels the hopelessness of resistance, or perhaps the steady force of the bench at last cuts the commotion. In any case, this is the emotional conclusion of the hearing. Law is conquered, not conquered by arms, but by framework. Kindly moderates righteousness, and power restrains grace. It is a unicorn moment to the audience on how upholding justice and grace is a delicate balance practiced by good judges. It might have gotten into contempt charges, or the hearing may have gotten out of control. Rather, it is left with procedure, principle, and control intact. But the tale is not finished here, since all the lessons of the courts leave us asking a question after the gavel sounds. What have we just heard about justice and about ourselves?
I need time to review the
What does
documents.
that mean?
It means I just got the documents and I haven't been able to review them, and I need time to review them. Your Honor. I can't decide on something and request for something right now in this moment if I haven't reviewed evidence.
So all you want is an adjournment?
After this response that I submitted to her and she submitted back, yes, sir, Your Honor. Adjournment for pretrial, adjournment for discovery materials.
You know something, sir? Just because you use what seem to be legal words and try to place them into a sentence doesn't mean that it makes sense.
I understand that, Your Honor.
No, I don't think you do. I think you were just placing words in sentences, thinking that because what you're asking for makes no sense. And if you think it does make sense, then maybe this court needs to send you for a competency. And I'm not saying that jokingly. This doesn't make any sense. I'll grant your adjournment. Next time you'll need to fill out a sheet to do it, but I'm not going to waste the time today to do it because...
Thank you, Your Honor.
And Your Honor, for the record, I've put the email address the defendant should contact for discovery on this Post-it note, which I'm going to place here, and he can pick up. He's indicated he doesn't want to communicate with me about this case.
He doesn't want?
Oh, at
He
that
doesn't want to
moment.
communicate with me about his case earlier, so I'm not going to speak with him today about this case, but I've given him the Post-it note to get discovery.
Oh yeah, that's a good way to get this going. All right, probable cause conference. Let me at least have some turkey before I have to deal with this again. December 5th,
Thank you, Your Honor.
2024, 9 a.m.
The lesson beyond the verdict. When the hearing finally adjourns, silence fills the courtroom. McGuff leaves still unconvinced, still tangled in his own narrative. But the audience, and anyone who's ever questioned authority, leaves with something deeper: understanding. The true power of law isn't in coercion, it's in consistency. Courts don't operate on emotion or belief, they operate on evidence, process, and precedent. Whether you agree with it or not, that structure protects everyone, even those who reject it. Judge Simpson's handling of McGuff's case is more than judicial routine. It's a portrait of modern justice under pressure. In a world where misinformation spreads faster than truth, where anyone can believe they've found a loophole, this case reminds us that legal knowledge is not the same as legal wisdom. McGuff's defiance mirrors a wider phenomenon, a public increasingly skeptical of authority, seeking power in misunderstanding. But authority, when properly used, is not the enemy. It's the safeguard that keeps fairness alive. For viewers, this case becomes a living civics lesson. Respecting the process doesn't mean surrendering your rights. It means understanding how to use them effectively. McGuff fought against the system. He could have worked within it. And that's the tragedy and the teaching of this moment. As the gavel falls, you can almost feel the weight of the lesson. The law doesn't need your belief to exist, but you need to understand it to be free. People will tell a story about this or that courtroom. Not many of them tell us so much about human nature. McGuff. What began as a mere hearing turned into a masterclass on the subject of patience, misunderstanding, and power of process. Judge Cedric Simpson is the one who made the world realize that justice does not scream, but it stands. The fight that McGuff had to fight was not only a legal fight, but also an existential one. His struggle with power depicted the perils of knowledge without understanding. This is at least one thing that anyone can learn. Law does not encourage defiance. And in the long run, listeners get to learn more than people who argue. Now, thank you for watching. To appreciate such in-depth coverage of actual courtroom scenes, subscribe, switch on notifications, and be with us next time as we get to expose the untold secrets in the justice system, one case at a time.